You may be watching this program today because you have been sued, or you're about to be sued, or perhaps you have a judgment that has already taken against you. And what you need to do is find a way to basically lose your assets quickly. So a lot of us are going to think right away, hey, I'll just give all my assets to my children. I'll give all my assets to my wife. I'll transfer it to a trust or an LLC or a whole list of other ideas. But that can be a problem. Because if you do that, that will not work. The reason it will not work is because you can set yourself up for what is called a fraudulent conveyance or a fraudulent transfer. And basically, the creditor or the person that has the judgment against you can go to a court in your particular state, or if it's a bankruptcy trustee, they can go to federal court and they can essentially have the court undo whatever it is that you've done as far as transferring your assets. So you want to understand what a fraudulent transfer is, and you want to make sure you avoid a fraudulent transfer at all costs. Hello, my friends. JR Dukes here with JRDukes.com, and I want to welcome you to the JR Dukes Show. Today, we are going to be talking about something that I get a lot of questions on. We're going to be answering the question of what exactly is a fraudulent conveyance, or what is called a fraudulent transfer? What can I do to avoid fraudulent transfers? We're going to answer those questions today. For the purposes of our discussion here today, I am going to use the term of a fraudulent conveyance or a fraudulent transfer as basically being synonymous and one and the same. I will discuss the technical differences between the two, but when I reference one, I'm basically talking about both. Now let's define a fraudulent transfer or a fraudulent conveyance. Basically speaking, a fraudulent conveyance or a fraudulent transfer is an attempt to avoid a debt by transferring money, assets. Most of the time, the state law requires it to be a non-exempt asset, and essentially you're transferring that asset from your name into another person's name or another company's name. That is what we call a fraudulent transfer or a fraudulent conveyance. Let's define exactly what a transfer is. A transfer is where you give away money or an asset to another person, another individual. As far as what we call a conversion, a fraudulent conversion, what we're talking about there is essentially where you're giving away a non-exempt asset and you're receiving another type of asset. Generally, it's going to be an exempt asset, but not necessarily. A good example of a conversion would be where you give cash and in return you receive an annuity, which in most states is exempt from judgments or from garnishments or collections. Now, there are two types of fraudulent transfer. We have one that is called the actual fraud, and the other one is called constructive fraud. I don't want to get too deep in the woods on this in this particular video, but I do want to cover the basics so you have a general understanding of the difference of the two. Essentially, the differences between the two boils down to what were the intentions of the debtor at the time the debtor made the transfer. The differences between these two types of fraudulent transfers boils down to the following. What were the intention of the debtor at the time the debtor made the transfer? When a court looks at a transaction, let's say you go to court, you get pulled in by a bankruptcy trustee, which is frankly a worst case scenario, or if you get pulled into court by just a general creditor that is trying to collect a judgment against you, and you're pulled in before the court, before the judge. Generally speaking, most states look at what we call badges of fraud. And these badges of fraud is essentially what they will look at in determining whether or not the transfer that you made is a fraudulent conveyance. Basically, these badges of fraud boils down to this type of circumstantial evidence as follows. Becoming insolvent as a result of the transfer. In other words, if you transfer all your cash to another person and then you have no money and you're worth nothing, that is considered a badge of fraud. Another badge of fraud is lack of adequate consideration. That's a fancy way to say if you sell a piece of property, did you receive in return just compensation? A quick example of this would be if you sell your car, did you sell it for fair market value or did you receive $10? If you receive $10, more than likely the courts are going to look at that as a fraudulent transfer. The court will also look at the transfer, was it made to a son, daughter, a wife, basically someone within your close circle of friends. Another badge of fraud is basically going to be as to whether or not at the time you made the transfer, was there a pending litigation? Did you know of pending litigation? Was there a threat of pending litigation? A few other things that they look at is the financial situation of the debtor at the time the transfer. Basically, what they're saying here when it comes to these badges of fraud is, does it smell? Does it look bad? When it comes to these badges of fraud, you can read the list that I have on your screen right now. Essentially, what this all means in layman's terms is a court is going to look at each transaction itself. Basically, did you transfer it for just consideration? If you sold a car, did you get fair market value? Did you transfer it to a wife? Did you transfer it to your children? Somebody within your close circle of friends. Basically, they're going to want to know if it smells. If it's a situation that just doesn't look right, the court is probably going to set it aside. Essentially, if it doesn't pass the laugh test, the court is going to set that particular transfer aside, and they're going to order the transaction reversed. Basically, if it does not pass the laugh test, the court is going to reverse the transfer, and that is going to be very bad news if you're trying to avoid a particular judgment. Also, I do want to point out briefly that a fraudulent conveyance, no matter how it sounds, generally speaking, is not criminal. It's a civil situation. The courts generally will not penalize you more than basically causing the asset to be reversed. But what you do have to be careful of is when you transfer assets to someone that's within your close circle of friends, say your wife or your children, if and when it goes to court in a fraudulent conveyance type action, you're essentially going to be bringing your wife, your children, your friends, whomever, into your litigation, and that is always going to be bad news. In short, you cannot just give your assets away and consider it solid, good, prudent asset protection planning. It just will not work, especially if you have a motivated creditor, especially if you're in a federal bankruptcy situation. I've made a video before pertaining to the way bankruptcy works and bankruptcy trustees work, and trust me, that whole situation, in my opinion, is a complete and utter scam. And if you're in a bankrupt situation and you're trying any type of shenanigans, you're going to be sorely disappointed because the way the system works is crooked. Again, in my opinion, I have a video that I made not too long ago concerning this subject, and I encourage you to check it out. Now, let's talk about how to avoid a fraudulent transfer. Obviously, when you transfer your asset, you want to sell it for what we call fair market value. Going back to the car illustration, if you sell a car and the Kelley Blue Book value for that vehicle is $10,000, you need to sell it for pretty close to $10,000. Probably the most important thing to do when it comes to asset protection is plan ahead of time. Take action before you actually have a problem, before there's actually a lawsuit or the likelihood or threat of a lawsuit. I always encourage you to consult an attorney in your home state when it comes to anything, especially asset protection. I was talking with someone the other day, and they were talking to an advisor that was out of state, out of their jurisdiction, and I strongly encourage you to not talk to someone outside your state. You want to talk to someone familiar with the state laws in your particular state. The takeaway from all this is at the time that a debtor becomes aware of a lawsuit or a problem, you must be very careful from that point on with any transfers of the assets that you make. I did receive an email in from one viewer, and the viewer says, "Nice one. Do you think that moving funds between unsafe accounts to safe accounts would be considered fraudulent by itself? I know that in-kind transfers are okay, but doing it when a case is ongoing might be another straw for the plaintiff to appeal that." Okay, thanks, Red. I think what Red is asking here is when you're talking about safe accounts, you're probably talking about accounts that he's had for some time and that are maybe not in his particular name. At any rate, again, Red, you want to be careful of anything you do, especially at the time that you know or should have known that there was a pending litigation or pending claim. Do I think moving funds between the accounts could be fraudulent? Again, it's every transaction out of your checking account is going to be reviewed potentially by the court, and you're going to have to use the criteria that I showed you earlier in the badges of fraud in determining whether or not the courts will determine each and every transaction to be appropriate, to be valid, to be basically normal. All right, Daniel asked me, what if there is no judgment, but yet it might come any day? Am I protected from fraudulent transfer when transferring money to an LLC before the judgment? All right, Daniel, in your situation, I'm not quite sure. I don't know if there's actually something coming your way as far as a lawsuit, or if you're just trying to be very proactive in this situation. Again, if you know that there is a potential lawsuit, any transfers you make as of that point are going to potentially be reviewed by the court. The best plan is to look at the previous videos that I've made and to familiarize yourself with asset protection in general and find a knowledgeable attorney in your area, in your state, and consult with them way before you have any kind of problem or any kind of litigation issues. That is always the best advice. At any rate, I do appreciate your questions. I appreciate you joining me today. If you have any questions for me, don't hesitate to reach out to me at ReachJRDukes@gmail.com. I'm always here if you have any questions. If you have any questions about this particular subject, don't hesitate to contact me. At any rate, I appreciate you joining me today. It has been my pleasure. If you like these type of videos, if you like the type of commentary that I like to talk about, please go ahead and click the subscribe button below, hit the thumbs up button. That way you'll be informed of when my future videos come out. Thanks for joining me today. As always, I am J.R. Dukes.